Right? Khadija Umar versus Meera Lakbe, 1903. In this case, actually, here the grandfather, the old man is the grandfather. Grandfather handed over his property to his son with a condition, fideicommis. What is that condition? 1/4 of the property should, right? Quarter, it's mean the quarter. So 1/4 of the portion of property should inherited to an outside, not within the family, to an outsider. This 1/4 portion should go. Only 3/4 portion can be enjoyed or inherited within the family or to the children. That is the fideicommis or the condition which proposed here by the grandfather. According to that condition, the father, right, got his portion. So that was the last will of the grandfather. 1/4 should go to the outsider. So according to that, father got the portion. Right? Now, the property of the father should inherited to their children. The father had 3 sons and a daughter. There are 4 children now to the father, 3 sons and a daughter. Now, according to this, the property of the father has divided to 4 parts and 3 parts have inherited to his son. Right? He has given his 3/4 portions to his sons. And he refused to give the last part, 1/4, to the daughter, and he has gave it to an outside. Right? This is the conditional gift, which is the last will of grandfather. Now the father also followed it. Now father's last will also this particular condition, which is 3/4 should inherit to his son, not to the daughter. The 1/4 portion, the last portion, will inherit to an outside. Right? That is gift to the outside. So now the daughter, what she is doing, actually, so against his father to the court with the reason of reivindication. What is reivindication? Reivindication means actually filing the case regarding the property, which is asking the property to separate again and get, right? Filing the case in the court to separate the property fairly to all the children. That is reivindication, meaning of that. So she filed a case in the court regarding the reason of reivindication, that the separation of the property of my father is not fair. So the court should fairly divide it and give. So she raised 2 questions: whether she enjoyed the last part, 1/4, which is inherited outside to her, or else getting the property back, which is given to the 3 sons, and dividing that to Pair four parts accordingly. That is her two questions, which is, I tell it again, whether to enjoy the last part of the portion to her, give that portion to her without giving it to the outsider, or retaking the property which is given to the sons and dividing that to four and enjoying for these four people, four children, fairly. Now the court said the fideicommisum or the conditional gift is not used in Sri Lanka. It's not used in Sri Lankan Muslims. But has the last will of the father, it should consider with the Roman Dutch law. So in Roman Dutch law, there's fideicommisum, right? So Roman Dutch law has again filled the gaps in this. So according to the last will of the father, cannot do anything. The daughter should remain without the property, and sons has a father's will, they will inherit. At what happened in H.W.Tambiah versus Meera Leppe, 1903. Next, another case, Idrus Satok versus Siti Leyuddin, 1950. In this case, actually, in the case Idrus Satok versus Siti Leyuddin, 1950, whether the minor children can take the gifts or accept gifts. Scenario also, the Mohammedan court was silent. So, according to Roman Dutch law, minors cannot accept the gifts without the consent of adult. So, adult consent should be there with the acceptance of gifts by minors. Next, another separate topic, not the donation of gift. In the donation, gift or gifts, we studied a case called H.W.Tambiah versus Meera Leppe. Right? The laws regarding the donations. Also, another case called Idrus Satok versus Siti Leyuddin, 1950 case also. Now we are going to learn about Muslim trust or waqfs. Already I told what is waqfs, funds which used for moral things. Muslim trust mean actually use of funds. Our Muslim trust. What is use of funds? Use of funds mean collecting profit, administrating someone else's property with the consent of owner. That is use of trust. And the waqfs, these two manage under the Muslim trust and waqfs. We know these two govern under the Act, Muslim Mosque and Charitable Trust, that is the use of funds, or Waqfs Act 1956. Right? Next, I like to explain you the contrast between Islamic principle and Mohammedan code. Already we studied some of the contraries. Now I would like to give you with the table. In Islamic principle, gifts are irrevocable. But in Mohammedan code, gifts are revocable unless it's stated revocable. Right? Also, regarding the gifts, in Mohammedan code it stated there should be evidence. In Sri Lankan code, there should be evidence for everything. So in Mohammedan code also it stated delivery possession is the evidence for the dowry.